media and social media policies, which, as Carly was explaining, this has obviously expanded tremendously over the years. And, we had originally had social media as a place to share photos, and life events with family, but now it's much broader than that. And you'll find that people are sharing their political views, they're expressing gripes about a product, and sometimes they're even discussing work. And, for employers, there is very little that you can do generally to restrict non-work activities of your employees. And really, generally, why would you want to even kind of go there? But the line begins to get a little bit blurred when we're talking about the fact that social media is 24/7. And so there are times where these non-work social media activities could in fact impact the employer. And this is why a social media policy is so important. But obviously equally important is that the social media policy complies with the law. So on that note, let's get into some do's and don'ts. So some do's in setting up a social media policy are setting clear expectations, being transparent, protecting your brand, but always keeping in mind that you want to be an employee advocate, working with your employees, and on that same note, considering the benefits that social media can have when used by your employees. What you don't want to do, hide the ball, alienate your employees, especially with outdated policies, because social media is evolving, and ignoring that it's out there is definitely not going to work. But a very important issue to consider is that you don't infringe upon protected activities. And that goes hand in hand with the NLRA, which you definitely do not want to ignore. The NLRA, or National Labor Relations Act, is a federal law which protects employees' rights to engage in certain protected activities like forming unions. And we'll get into that a little bit more in a minute. But another very important thing to consider is to keep updating your social media policies. You want to assess it every now and then to see if there are updates that are needed, whether that's because the laws have changed, or because there's some new social media platform which poses new issues. So going on to the National Labor Relations Act itself. So as I said, this is a federal law that grants employees the rights to form or join unions and engage in protected concerted activities to address working or improve their working conditions. It applies to both union and non-union employees, applies to most private sector employees. And the National Labor Relations Board, or NLRB, is an independent federal agency which enforces the NLRA. So the NLRB has actually addressed in great detail certain social media policies and has provided guidance on these. You can go to the NLRB website, and they even have guidelines listed there. So what sparked their involvement was there were employers that had reached out about basically seeking guidance. And so in 2010, the NLRB had at the same time been receiving complaints regarding employers' social media policies. And when they looked into it, they found reasonable cause that some of these policies had in fact violated federal labor laws. In response, they issued 3 memos in 2011 and 2012. And so we'll go through some of these general counsel memos. So the first one, sorry, next slide. Yeah, so the first one was on August 18th, 2011. And there were a number of different cases assessed, but one of these was relating to activities on Facebook. And what it involved was it was a nonprofit social services provider, which was found to have unlawfully discharged 5 employees, one of whom had initially posted comments on Facebook relating to various allegations of poor performance. So the supervisor had been complaining and criticizing the work of various employees. And with regard to one of these employees, was also texting them rather regularly. And so one of the individuals went onto Facebook, and they posted some comments about what the supervisor had said, and also asked other employees to chime in and say, give their thoughts, what they thought about this. So 4 employees did chime in and gave their response. And the following day, the supervisor went into work and said that they felt that this was cyberbullying. And all 5 of the employees, the original poster and the 4 who commented, were terminated. So the NLRB looked into this, and they determined that the discharged employees' postings on Facebook constituted what they call, quote, protected concerted activity. The board found that the employees did not lose the act's protection simply because this was done online. It was very clear if this type of thing were to have been done in person, but this was kind of the initial time where they started to look at it in the context of this type of speech online. So the next one was on January 25th of 2012, and it involved disparaging the employer on social media. So the discussion in this regard was twofold. One was they were looking at the actual social media policy, the language that the employer had, but also the response taken by the employer. So the employer had a social media policy which prohibited making disparaging comments about the company through any media, including online blogs or electronic media or through the media. And an employee was upset about a perceived demotion that they had received. And she posted on Facebook about her experience and used certain expletives when discussing her employer and saying that they'd done the wrong thing and that she was a good employee. She was friends on Facebook with a number of different employees, and a number of them posted comments in solidarity. And one of these particular employees even referenced a class action. When the employee returned to work, she was terminated due to her comments. So the NLRB first looked at the social media policy itself. So again, the language was, no posting or no making disparaging remarks or comments about the company through social media or any media. And they said that this was problematic because it arguably restricted the employees' right to speak about fair treatment, so the conditions that they worked in. And then on the other end, the response that the employer had by terminating the employee, they said that was also unlawful because it was in response to the employee basically speaking out about their rights, and because there was this discussion about class action. So then on May 30th of 2012, they issued a third memorandum, and this was in relation to confidential information on social media. And this is obviously a common concern that many companies might have, that you don't want confidential information getting out there, and that makes sense. What this dealt with was the way in which this is communicated to employees and the problematic language that they found. So in this instance, the employer's policy had a section that said, don't release confidential guest, team member, or company information. So the NLRB found this to be unlawful because this could reasonably be interpreted to be a prohibition of discussing their own conditions of employment, similar to the last slide, as well as the conditions of employment of other employees. For example, if they were to discuss wages, if the employer were to say that was confidential, that's the employee's right to have that discussion. And so because the employee could reasonably construe that to mean that they could not discuss the terms of their own employment, that policy was unlawful. So we'll move on to NLRA Section 8A1. And this is not about social media specifically, but I thought it would be interesting to look at it through the lens of social media. So in this particular case, there was an employee who was basically asked a lot of questions by their supervisor about whether they were forming a union, asking question after question. And when the employee said, "How do you know? How do you even know that it's me?" The individual said, I don't know, and basically gave this impression of surveillance, that they were watching this employee somehow. And so the NLRB found that stating that the employer knew about the employee's activities, but not revealing how they knew, created this impression of surveillance. And so my thought was, what if this had been on Facebook? The supervisor has gone online and seen this, and then the employee they have a discussion with the employee, same scenario, but instead, the employer doesn't say, well, I saw this on Facebook. It gives that impression of surveillance, similar to what the NLRB found in this case. So one situation where the NLRB was actually, an example on the next slide of a situation where the NLRB's decision was actually overturned by the court, involved a situation involving disloyalty. So this particular instance was Micklin Enterprises. And what had happened here was the employees of Jimmy John's had complaints about their employment, that they weren't getting enough sick time. And so what they did was they posted two images, both side by side, of a Jimmy John's sandwich. But on the left side, there was all caps, "Your sandwich made by a healthy Jimmy John's worker." And then on the right, it said, "Your sandwich made by a sick Jimmy John's worker." And then beneath it, it said, "Can't tell the difference? That's too bad, because Jimmy John's workers don't get paid sick days. Shoot, we can't even call in sick. We hope your immune system is ready because you're about to take the sandwich test." So the NLRB had originally found that the employer had violated the NLRA by discharging these employees. But then the Eighth Circuit overturned this, saying that they had violated the NLRA because this was disparaging conduct. They had intended to harm the company. When it's disloyal, it crosses that line where there perhaps is a better way to communicate the gripes that the employee has. But in this instance, it had gone beyond that. And so it was found to be problematic. So moving on. So this, as I've mentioned earlier, the NLRB has guidelines, some examples on the website, which are helpful to look at in terms of seeing examples of language that they find to be okay. And when you compare what we talked about earlier, where we were talking about confidential information and having a policy that you don't want to have that's very broad and could encompass employee information and infringe upon their ability to share information about the terms of their employment. In this instance, the policy here says maintain the confidentiality of employer trade secrets and private or confidential information. So that's much more narrowly tailored to specific issues. So moving on again to drafting an NLRB compliant social media policy, what you want to make clear is that the policy is targeting illegal activities as opposed to protected activities. Your social media policy should reinforce your anti-harassment and anti-discrimination policies. Policies that require employees to maintain confidentiality of trade secrets, as we discussed, that's fine. That's targeting, you're trying to target illegal activities, not ones that are protected. So what you don't want to do is create overbroad policies. So when this happens, it just creates big problems. You want to avoid a policy which would say something to the effect of, as we talked about earlier, you are prohibited from discussing confidential information about your employment. Maybe you say something instead, employees may not disclose proprietary information about a company client. That takes a very broad policy to something more specific. And you want to embrace neutrality. So what I mean by that is you want to create policies that where it wouldn't be construed as target certain types of speech. So to give you an example, which isn't in the realm of social media necessarily, but is an example that I'm sure people may have experienced on some level, is the issue of mask wearing. So, if you had an employee coming to work and they were wearing a mask and it said something like #MeToo or something like that, if the employer doesn't have a policy in place that just says no language whatsoever on a mask or an item of clothing, and if that same employer who doesn't have a policy asks the individual to take the mask off and put one on that doesn't have language on it, then that could look like they were targeting the speech that was being communicated, as opposed to enforcing a policy that was intended to be neutral. And I mean, this is a tricky area, but at least if you have a policy and it is neutral, then you can point to that policy if the employee were to call you out on that. So the next area that I wanted to go through was California specific. And, we have talked about the NLRA, but there are definitely state laws which provide similar protections to employees and which employers should be aware of. So in California, that is California Labor Section 96K and 98.6. So 96K provides the Labor Commissioner with the authority to assert claims for lost wages on behalf of employees that arise from retaliation for lawful conduct occurring during non-working hours and away from the employer's premises. And 98.6, hand in hand, protects an employee who files or threatens to file a claim due to this non-work activity. So basically, this is targeting retaliation for conduct during non-working hours. But the key again here is lawful conduct. So in recent past, we've seen media attention over companies firing employees for certain political activities. And at least in California, an employer should be very careful about this. If the employee is, for example, lawfully protesting, adverse action could result in a wrongful termination claim. But again, if it's unlawful, if the employee is engaged in some sort of unlawful conduct, that's different, and that's what this addresses. So attributing views to the company, this isn't necessarily hand in hand with something that's unlawful per se, but if you have a policy regarding this that you express in your social media policy regarding the employee expressing views as if it were that of the company, then you can point to that particular policy as being a violation of the policy itself. So again, neutrality is very important. You want to make sure that you're treating all your employees the same way. So, you may have a neutral policy in place, but is it actually being carried out in a neutral way? So for example, if you have one employee or if you have a policy, an attendance policy, and an employee misses work to go to a protest and another misses work for some other reason, are you enforcing that policy the same way and not specific to a particular activity? So next, I wanted to get into the do's and don'ts of social media for brands and businesses. So the first area is responding to negative reviews. So this is kind of getting at best practices. What you want to do if you see something online that there's a complaint, assess the nature of the complaint and the credibility. Credibility can be important if you have somebody who just is a serial poster, constantly providing negative comments with nothing really to back it up. That's something to assess. And you want to prepare responses that are productive and proactive. You do not want to be combative. So, the reality check here is that people generally understand that negative reviews exist, and they use their own filter in coming to a conclusion. So it may make sense to provide a response to a complaint that's made, but maybe not to the specifics of the complaint. You show that you care, but maybe not in too much detail. So we're looking into this issue, the experience identified by this post doesn't align with our values, that type of thing, but not necessarily getting into the specifics of the post. But I think when people who are going and looking at the reviews, they appreciate in certain instances seeing that the company takes it seriously. So moving on that note to Yelp reviews. So what if someone posts negative comments that turn out to actually be defamatory? Well, this came up in a California case, which involved a disgruntled client of a law firm who posted 2 negative reviews that were defamatory. The attorney reached out to the former client and asked her to remove the defamatory statements, which she refused. So the lawyer sued, and the court, in fact, ordered this woman to take the posting down, but she didn't. And so the question then became, could Yelp be forced to remove this comment? And the California Supreme Court answered that question with a no. And so under the circumstances, Yelp could not be held liable for content that it did not create. So it's important to remember that there are limitations on what you can do about issues like this, but you certainly want to address them when it's appropriate, when something is important. So next is brand identity. So when you're making various postings about your brand, you want to be consistent, concise, accurate, and be mindful of your audience. Depending on your audience, some things might sound like you're alienating them. This is for upscale consumers only. That may or may not be appropriate, but these are things that you want to consider before posting something online. So finally, we get into, just generally the notion of being proactive. You want to foster communication with your employees, engage in a dialogue with them, update your policies regularly. You want to make sure that your policies comply with the law. You have protocols in place every 6 to 12 months. The laws change and your policies should change with them. And you want to evolve with social media. Understand that social media is constantly evolving and your company policies should evolve with them. Thank you.
So with that said, Emily, just a couple of questions that have been posed. So if you are in the process of creating a social media policy for your business, what are the main points that a company should be looking at or looking for when they're creating those policies? How detailed should they be or not be?
I mean, I don't think that you want to have an encyclopedia of a social media policy, but I think you do want to outline some, general ideas that are important to the company, and that may depend on whatever industry that we're talking about. Copyright, trademark issues may be somewhat of an issue for some companies, but a very big issue for others. And so that may be something that there's a large focus on. But I do think that in creating any of these, it's important to look at what types of social media are out there, and if these policies are going to in some way infringe upon speech. And so you don't want to have some very long thing, because I think that would then make it overbroad. But it's certainly something where you want to look at the industry that you're in, because there may be issues which may not be an issue for some other company, but for yours specifically, that may need to be addressed.
Thank you. The next question is for Freddie. Freddie, along with your GL nugget about, smart plaintiff counsels looking for information online, what do you have for our audience in regard to the general liability policy itself? Because as you were aware, someone could walk into your business and then later claim that they were harassed, or that they were not treated the same because of their race, skin, or color skin, or anything else. What are your suggestions for businesses to protect themselves from getting, those type of attacks on social media, and to prevent those type of things from happening?
Great question. I think a lot of it is you can't have something that's too specific, because then you're trying to cover every potential fact that could come up. And then you end up with a policy that is overwhelming for your team, and a policy that frankly may not be realistically followed. And keep in mind, these policies often can be discoverable, and it may be pursuant to a stipulated protective order, but they may be discoverable. So if you have a policy that is too precise, and it turns out that an employee was not able to follow that policy, either because it was just overlooked or they're overwhelmed, that's almost worse than having a broader policy that allows some discretion. So I think the best thing you can do, obviously these policies can be very intensive. Do that along with counsel. This isn't something that you should just kind of wing. It's something that you should do in conjunction for your companies out there on this. Do it with trusted counsel. And for the claim specialists here, when you're helping your insureds and you're issue spotting with these issues we're talking about here, make sure they're not just the companies are feeling like, okay, we're going to give this a shot. Reach out to trusted counsel as well to help you walk through this process, because there are a lot of landmines here. And I think a big takeaway from this from this presentation is issue spot. And then once you issue spot, you know what needs to be addressed, and do that with people that have the experience to help.
Well, I remember a scenario with a claim that I handled many years ago where when social media first became prevalent, there was a patient that was in a managed care type hospice situation and was not getting the best care. And their daughter went on to social media and, I mean, really not just attack the facility and the type of treatment that her father was getting, but also physically threatened the people that worked at the hospital environment. And so I remember the hospital saying, you know, we're going to call this person and ask them nicely to take this down because we consider this a threat. And in today's society, you know, those type of things really have to be taken at face value sometimes. Even if you're writing them in the heat of the moment, what I want everybody to understand is that threat to a business, saying that you're going to come and cause bodily harm to someone in a business, those are taken very seriously nowadays, especially with, you know, people walking into businesses and shooting the place up, so to speak. So in this case, you know, the person did take their comments down and, you know, made an apology. But, you know, what would you say, you know, to the businesses that are out there today about, you know, those type of comments that are placed on their page? If they feel threatened, you know, what do you think their first recourse should be? And that's to either.
Well, I mean, I think obviously, again, it depends on the type of, you know, statements that are made. But I think in terms of if there's a threat to their employees or, you know, to their business, they have to protect their employees. And so I think, as you say, I mean, there has to be some form of action taken because you don't want a situation where you just let that be, didn't take it seriously, and then something happens. And, you know, whether that means contacting the person directly, which I don't know, poses some issues, I guess. But, or, you know, I guess if it was extreme, reaching out to authorities, that type of thing. But I definitely wouldn't just leave it if it was credible and there was a threat to your employees.
I agree. Freddie, do you have any comments about that?
No, I think something to keep in mind, though, is be prepared before anything like this happens. Another takeaway is, you know, you don't want to play it by ear necessarily, although, as Emily suggested, you can't account for every potential thing that may pop up. But you can proactively in these policies figure out who is on the team that is going to be addressing things like this that could be popping up. And so that way, you know ahead of time that this is the group that we're going to refer these to flesh out what our next steps will be.
Yeah, and I can say from personal experience, I would be mindful if your company has a Facebook page or any type of page on social media where people can leave reviews and comments, that you never get into an argument or never allow your employees to get into an argument with that person, especially if the comments are pointed at one of your employees. I've seen some of the worst back and forth with businesses in my career where someone will say, hey, you know, this person didn't take care of me, this company is junk, you know, don't ever utilize them. And then the employee takes offense and jumps on and just, you know, starts going back and forth, which should be a really big no-no. I agree with what you say, Freddie. I think that having that point person or your marketing director who's actually over your social media to respond to those things is probably a better practice than allowing your employees to engage in an argument, especially on your business page. That can cause a lot more harm than it's worth. And, you know, sometimes people have valid arguments. You know, they have valid complaints. And if you don't take those complaints and run with them the correct way, it can negatively affect you and your business regardless of the situation. It could have been the most minor of situations, and you still have a huge duty to the people that you answer to, whether it's a boss or the board of directors or the CEO or whatever of your company. You want to make sure that you're protecting your brand at all times. So, watching what you say to people and just not engaging, first of all, didn't really engage in that. But having that point person is extremely, extremely important, especially in today's world.
Yeah, and Carly, another point too, a lot of this also comes down to training, because you can have the best policies put in place, but if you're not training your team about how to address things properly, you're not doing everything that you can be doing. So it's not just about implementing these policies, but it's also making sure that your employees are aware that situations like this can pop up and who to contact and what to do if these situations do pop up.
Yeah, I agree with that. Making sure that, again, brand protection is a big thing. We've seen some major corporations over the past, 6 to 8 months to a year go through some really significant problems because of postings or employees getting in trouble for posting. So having the right word when you're implementing policies and making sure that people understand, we don't want to stifle our employees as far as what they believe in and the groups that they belong to, but we also don't want anything damaging our corporate reputation, overall, if that makes sense. So I don't see any more questions in the Q&A panel. If anyone has any questions in regard to what we presented, we are running a little early, but we have slides for myself and Emily and Fred have our contact information. We will be glad to answer any questions that you may have in regard to the claims aspect of social media policies all the way through the legalities. Emily and Freddie, I cannot thank you enough for being with us today. You're two of my great defense counsels out there in California, and we really appreciate all the hard work you do for us. So with that said, I'm going to turn it back over to Matt, and we're going to go on break just a little bit early. Matthew?
Okay, well, thank you very much, Fred, Emily, and Carly, for excellent presentation. I think we have one more slide with the disclaimer that this isn't intended to be legal advice, so please digest this disclaimer. And, thank you again, Fred, Emily, Carly, and we are going to go on our last break before we proceed to our final session. So we're going to reconvene at 3 p.m. Central Time for our last panel on future trends.
Thank you. It's been a pleasure. Thank you, everybody.
Thank you so much.
Thank you.